certain intrinsic values or qualities that aren't real to the product, that's where you start crossing that line. But no, absolutely, the Supreme Court recognizes that there has to be some intrinsic puffery in every marketing and advertising program.
Right. You're not going to sell your product if you say, buy us, we're okay.
I think there was a movie in the 80s, what was it called? Strange People? I forget. It was about how an advertising agency enlisted the services of patients of a mental institution to create advertising slogans. And I don't remember all of them, but I do remember one, for some reason, has always stood out in my mind, which is the Volvo. And one patient wrote, "It looks like a box," or "It drives like a box." You know? And it took off. I mean, the country loved it. They loved the truthfulness. They loved the straightforward talking that these patients were conveying, instead of always being felt that they were being sold a bill of goods.
Let me ask you, since you mentioned Volvo, I'm just going to use this as an example.
Sure.
Say I go online and I decide I'm going to start buying domain names. And I find out, wow, nobody has www.volvo.com. Can I just buy that even though that's a protected name?
That's a really great question, and it's an issue that has really been fought out quite extensively in the courts and in different proceedings. Domain names really have essentially the same rights as a trademark, and the courts will often view domain names as essentially one other form of trademark that a company may have. And so where there's an individual who's intentionally registering or buying up domain names solely for the purpose of reselling those domain names or trying to divert business away from the real trademark holder to something else. So the courts have called that cyber squatting, where essentially these individuals are squatting on other people's rights. And there's a test with respect to what's the intention of the party. So in the case of Volvo, for example, if the person buys up Volvo and then sells that domain name to Ford, clearly that's just malicious infringing of one's domain name. On the other hand, if a person's last name is Volvo and wants to set up a website with pictures of his family, the person may actually have rights and be able to keep that domain name. There's the other issue that comes into play is how well known the domain name is. And to the extent that the domain, like for example McDonald's, to the extent that a domain name really takes on secondary meaning and everybody would attach a particular company or product to a domain name, then it's much easier to take the domain name back and give it to the rightful trademark holders. You said McDonald's, and you were talking about films from the 80s. I was thinking of Coming to America, and there's this guy who's running a fast food joint called McDonald's. Yeah.
Instead of McDonald's.
Clearly trademark infringement.
Well, you say that, but when I went to law school in Newark, instead of Kentucky Fried Chicken, they had KFC Country Fried Chicken, which was K-O-U-N-T-R.
Yeah.
How far can you push the envelope?
So that's a great question. So the answer is, under trademark law, the standard the courts will use is what's called likelihood of confusion. If the consumer is likely to be confused between different products, then the court will and often does find trademark infringement. Now, likelihood of confusion, again, is a very general statement, and the court has factors, tests that they'll run the two marks up against to see whether or not, based on these tests, there is what they feel a likelihood of confusion. But that's the test. So in the two cases you gave, it sounds to me like there could be likelihood of confusion, and the court would probably be likely to do something about it, to stop the infringing party's use of their other related similar domain trademark.
But when you say that, I'm thinking, going through the grocery store, there's so many products that look like other products.
Yeah.
I know there was a case where Virgin Cola had a red can with white script. It looked like there was a wave on it. It was very similar to Coke.
Right.
And they had some legal issues.
Right.
But there are many times where generic brands try and look like the Tylenol bottle, the Coke or Pepsi can, the fill in the blank.
Right.
Because they want to let the consumer know this is a similar product. And as a matter of fact, it will say, if you like Cheerios, try Grand Union-O's.
Right, that's right. So that gets into an area called trade dress. And trade dress is an outgrowth of the trademark, service mark protection or body of laws, where if a person has created a particular design or structure or even color that's so closely identified with a particular product or service, the court will actually grant rights into that design. So the classic example that I often use is the Coke bottle. You look at a bottle, you instantly know the shape, the structure, the size. That's a Coke bottle. And if you wanted to come out with some, with a grape soda in that same bottle under a different label, the court, and there has been cases on this, the court would say, sorry, that particular shape of the bottle is solely Coke's. But you're right, this is becoming a very crowded marketplace, and courts are constantly being bombarded with very difficult cases like the ones you've mentioned, which is really why more often than not, these cases end up getting settled because it's less costly, and usually you can get a much better outcome. Both parties can get a better outcome by settling and coming to some terms, some coexistence agreement that allows the trademark owner sufficient rights to continue exploiting and protecting its trademark, but also not necessarily putting the other company completely out of business.
Well, we've been talking mostly about phenomena that really takes us into the past in the 20th century.
Right.
And I want to talk a little bit about what's coming up in the future. I'm thinking of maybe issues about the social networking sites and privacy issues that are connected with intellectual property, especially the genetic aspects of it. I know that there was a case where someone had been getting some tests done, and the researchers realized that the tests being done were coming out with unusual results. And so they took the subject's genetic material and they went and patented by altering it somehow. And the person didn't have an interest right in their own genetic material.
That's right, that's right.
I don't know if you're familiar with the case, but if you could talk about these issues. What's in the future for us?
Well, the future is, what was that song? The future is so bright, you have to wear shades. Have to wear shades. It's really, that's so much the case. Privacy is a major issue, whether it's financial privacy, whether it's just privacy of one's own life, whether it's genetic or health-related privacy. That's certainly a very important issue, and it's an issue that we're dealing with on so many levels. Representing several financial institutions, they're always trying to keep ahead of the legislation that's been passed to protect consumers' financial privacy information. We, of course, there's HIPAA, which is the body of laws that protect our medical information, which is very private. And I guess, word to the wise is be careful what you're signing. And you mentioned the social networks. How many people have Facebook